Didn't want to record me after. All right, so I'm going to start with a couple of quick disclaimers before we get started on the preparing for the end of the commercial eviction moratorium webinar. Among the things that you should be aware of is that where every one of the presenters is going to do the best they can to provide you with accurate information. You should always double check the information and make sure that you consulted with an appropriate advisor, legal or financial or other, on critical issues. This webinar will be interpreted in Spanish, Vietnamese, and Mandarin. I'm going to take a quick moment and ask each of the interpreters to convey that information in Spanish, Vietnamese, and Mandarin. So what I'd like to do is invite those who are interested in listening to the webinar in an alternate language to click the world that's on the bottom right-hand side of your screen, and you'll be able to select the language that you would like to listen to the presentation in with the simultaneous interpretation. Can the Spanish interpreter please provide that information?
Buenas noches. Si usted desea escuchar este programa en su idioma español, lo que necesita hacer es ir al icono del mundo en la parte inferior de su pantalla, oprima y seleccione el lenguaje español para poder escuchar el programa en este idioma. Gracias.
Gracias. And next, if I could ask the Vietnamese interpreter to provide the information that the audience can listen to the presentation in Vietnamese by clicking the world at the lower right-hand corner of their screen. If you are able to move to the main channel, you'll be able to let people know that in the larger audience. All right, sounds like there may be a little bit of difficulty on the Vietnamese side. Let me ask the Mandarin interpreter, one of the Mandarin interpreters, to let the audience know that they can listen to the presentation in Mandarin by clicking the world at the lower right-hand corner of the screen. All right, well, hopefully that information was conveyed to everyone so that they are aware of the possibility. I also want to let you know, in addition to the fact that we're going to be providing this interpretation in Spanish, Vietnamese, and Mandarin, we're going to be recording this. So if you have questions later and want to refer to them, you can visit our YouTube channel at the location listed here. Or if you know of somebody who might benefit from the information, it would be great to have them be able to access the video at a later date. A couple of other key issues is that we will be using the Q&A function to have you ask questions and for us to be able to answer them. In the event that the question is going to be of a wide range of interest, but we are not able to answer it immediately, we'll address it at the end of the presentation. Otherwise, it's possible that one of the panelists will answer the question as we go through. We'll also use the chat function to be able to communicate with you about links so that you can follow up with them if there are questions that you may have. Also, I'd like to ask if you would complete the post-meeting survey so that we have your recommendations on the types of things that we should be doing better next time, or if there are topics that you'd like us to cover. My name is Des Woodworth. I work with the City of San Jose's Office of Economic Development. My contact information is here. I'm joined by Melina Iglesias, Elizabeth Handler, Nathan Donato Weinstein, and Joe Hedges, each of whom are playing an integral role in making this event possible for you. You can reach us at the email at the bottom, the COVID-19 sjbusiness@sanjoseca.gov, or at 535-8181 if you have more questions. This is a series of webinars that we've been putting on since the beginning of the year, since 2021. We alternate BizChat SJ, which is an opportunity to have conversations with other small businesses about topics of interest to the attendees. We often will cover a smaller discussion item so that people have a chance to explore a particular topic. But we also, like this one, we offer more in-depth examinations of a particular topic. Our next in-depth review will be on June 24th, where we'll be talking about financing your business recovery. Just to mention, on the 17th, our plan is to actually talk a little bit about government procurement and ways that you can access that. And then we'll repeat the biz chat on the 30th, again, giving you an opportunity to talk with City of San Jose representatives and someone to talk about a topic of interest for that particular day. So today we're going to talk about the Santa Clara County, well, more broadly about the commercial eviction moratoriums, but in our case, Santa Clara County more specifically. I'm just going to kick this off quickly before we get to the panelists and give you the basic background, which is at the moment, the commercial eviction moratorium will expire on June 30th, 2021. What that means is up to that point, your landlord cannot ask you to leave before that date if you have not been able to keep up with your rent payments because your business was impacted by COVID. Under the eviction moratorium, you'll have 6 months to pay the first half of your back rent, which basically is the end of 2021, and you'll have an additional 6 months or 12 months in total to repay all of the outstanding amount, which would be the end of June 2022. The reason why we're asking the panelists to attend today is because there is still an opportunity for you to have an influence on this, and you shouldn't put it off because June 30th is right around the corner. Good for you to act now. There is a remote chance that the moratorium will be extended further by action by the governor's office. The county has provided for the possibility that that could happen, in which case the eviction moratorium would be extended until August 18th. However, I would not count on that. I encourage you strongly to recognize that the day is coming up, and it would be really good for you to be mindful of that and take advantage of the information that's being provided by today's panelists. So we put together a great group of people who are going to be able to provide you with both technical information now as well as in the future. And we've invited Mel Weisblatt from SCORE to come and talk with you about the kinds of interactions that you can have with your landlord to effectively address the issues of the end of the moratorium. Greg Torrico will talk about the advantages of pairing up with Start Small, Think Big, which can provide legal and other assistance to small businesses. And then Rachel Boyce from Cooley will talk about more of the specifics about the legal aspects of leases and the kinds of things that you would want to be aware of as you are, again, approaching the end of the moratorium. So with that, I'm going to stop sharing my screen and ask Mel to share his.
Okay, let's see if I can do this right. We'll all get
right.
it. I'm assuming that you see that?
You're good.
Okay. Thank you, Des. These have been, I think, very invaluable to people, excuse me, to be able to listen to people talk about what they might or might not be able to do. A little bit on my background. I have been a business broker here in the area for 32 years, mostly retired now, but it's one of those jobs where you never quite really retire. There's always someone who needs your help, so you work with them. And I've been volunteering with SCORE for about 17 years now. I'll show you some slides at the end about what SCORE is, but SCORE is a volunteer organization designed to help people in all aspects of their business. So let me move on here. Part of what you have to think about when you're talking about negotiating or working with your landlord is think about the kind of space that you rent. There's certain kind of spaces, such as restaurant in particular and retail, very much so, that it's very difficult to move out of that space and try to get something else. People know where you are. With restaurants, you have all the leasehold improvements that you have in there. Manufacturing is one that's sort of halfway in between. It's the location is not that important, but all the leasehold improvements that you've put in have become important. Office space might be very easy to move and down space, and R&D space, depending on what it is that you're doing, and if it's particularly in high tech where you're working mostly with computers and other things, should be fairly easy to work with as far as moving. So when you talk with the landlord, let me move on here. You do have to talk about what your current lease situation is. I have seen really all kinds of statuses with the various leases that are out there. You may have a lease that has a number of years to run, and if you've gotten a if you've not been able to cover your whole rent during this period or parts of the rent, it's something that you really want to work with your landlord. And I'll talk about that in just a minute. This is particularly true if you have an option period on your lease as well. Some leases out there are already expired or soon to be expired, which which means, you know, this has to start new, and it may be a little more difficult at this point. And some of the people are really have expired, but because of the moratorium, excuse me, they're on a month to month. So with your current lease with years to run, keep in mind if you might have to pay as much as double what your current rent is to catch up within the 12-month period. And certainly if you have a lease with an option on it, most of the options will state that you can exercise the option if you're not in default of the lease. Now with the moratorium, if you haven't paid, you're not in default, that's sort of a given. But if you don't catch up with the landlord in the specified period of time or with what you've agreed to, this could make it very difficult. So one of the things I would suggest that you do is, first of all, think about if you can, I might as well go to the next slide and do this. Think if you can downsize, particularly if you're in office space and everybody's gotten used to working from home. One of the things you can do with the landlord is say, you know, I don't want to leave here, but I've got 3,000 square feet. Do you have any other office space I can get for 1,500 square feet? Thereby cutting your costs, but also, you know, it will endear the landlord more to you, also to work with you on the repayment. At the same time, you have to think about, you know, what you can do without, and downsizing comes with that. If you're going to move, how much will it cost you to move? Certainly manufacturing is fairly costly to move, may be worth it in the long run, but you have to put all these numbers together. And like I said, with things such as retail and restaurant, how important location really is, and how you don't want to lose that part. So let's talk a little bit about what you can talk to the landlord about. Now, obviously, if things are coming back very nicely and you can afford to pay the back rent, that's the best thing to do. You know, just figure your rent is going to increase by whatever it is that you haven't been able to pay while you've been in the COVID lockdown period, if I can call it that. Sometimes you might have to negotiate a little bit, particularly with retail and restaurants. Talk to the landlord about, you know, how you expect things to go forward from this point. But if you talk to the landlord, you really have to, what am I trying to say? You have to bring some facts to the forefront. So the landlord's going to want to really know about your business and what your plan is for getting everybody to walk back into your store. Bring financial statements of the several years prior to this, and also bring in a solid business plan for what you're going to do to return to normal business operations. One of the things you can do with negotiating with the landlord is to talk about paying so much money extra a month, plus a percentage of the income, gross sales, or just a percentage of the gross sales. So as your gross sales grow, you'll be paying it back in a way that's more affordable to you. And if things get back to normal, landlord gets paid back quickly. Keep in mind, and we always talk about this, the landlords have expenses too. They're paying their mortgages, taxes, insurance, upkeep, and they have to get this covered now. A lot of them haven't been getting very much money in the past year and a half. And so they're looking to catch up on this. And I'm sure they've had to do a lot of negotiating with their creditors as well. So think of all the options that might be possible. You owe the landlord money. Can you downsize, get a smaller space, but pay him the same amount of rent that you would normally pay to catch up on him? Like I said, one of the ways to talk to the landlord is to pay him percentage of gross for a while until you catch up. A lot of this will depend on your legal situation, and that will be discussed a little bit later, but it also will depend on your financial situation, what you're able to do. Other things are, you might offer to pay the landlord interest on what you owe him. Now, that's not something that's coming in, but makes him feel pretty good that, he's getting some interest on his money that he hadn't thought about, and so it gives him a little bit more money to deal with what his problems are. So make sure the landlord knows and make sure that you know and understand the landlord's financial needs, and make sure that the landlord understands your financial needs. And within this context, suggest some ways that you can come together. There are just a lot of ways. If you're worried about, because we're kind of hoping to open up fully in the middle of the month, that it may take 2 or 3 months, talk to the landlord about, well, we'll pay you a little bit more in July, a little bit more in August, and then by September, we hope to be rolling. And if you're in retail, hopefully the Christmas rush, you'll be taking in a lot of money and be able to pay him back a little bit more. Always ask for his help. Never threaten and say, if you don't do this, I'm going to leave. People don't like to be threatened. People really will help if they possibly can. If they see that you're honestly and sincerely working to come to a reasonable conclusion, yeah, they'll go ahead, they'll work with you, they'll come out with something. So I mentioned before, talk about some long-term repayments. Maybe a year is going to be too hard for you, but just because it says you have to pay back in 12 months doesn't mean you and the landlord can't work together and say, how about making it 18 months or 24 months? The landlord may want you to sign a note for that, and that's fine. And as I mentioned just a slide prior, suggest ideas for easing back into full rent. The whole notion that just because June 15th comes and quote, everything is wide open, doesn't mean that people are going to be flocking to your business or your employees are going to be coming in. And particularly if you're in manufacturing, if all of a sudden the people that you're supplying are going to want loads and loads of material. Moving on one more here. So anyway, I mentioned and touched on some of these things. One of the things that you can do if it's retail and you don't want to lose your location is maybe there's a smaller store in the same shopping center. It's easier to keep customers if you're 5 doors down than if you're a mile away in a different center. Again, the cost of moving is there, and you need to assess the cost of moving with the saving of rent. It particularly is good if you can move into a space that your current landlord owns, so they're not totally losing a tenant. Some of these things really won't have much use, but frankly, there are some really worst case scenarios. You don't see business coming back. It's just not going to work. It's terrible to say, but that might happen. So you may have to negotiate with the landlord for a buyout of your lease. Usually they look for several months' rent and then they let you off the hook. But keep in mind, you've signed the lease as a personal guarantor. So you owe the landlord rent for 5 years or whatever it is. Sometimes if your lease is close to expiring, you can follow through and just wait till it expires and walk away. Now, if you're on a month to month, you have no obligation. Of course, the landlord has no obligation to let you stay there either. So these are some of the things to look at. And there will be, unfortunately, I'm sure there'll be some worst cases where people just won't be able to do it. Business is not going to return. So one of the things that I've learned in selling businesses is successful negotiations. And those are always win-win situations. I know it's easy to say, but the thing is, it can be done. So what you need to look at is what's the landlord wants and needs. If he's in a bind or she's in a bind where they need a certain amount of money every month, to go below that won't work for them. So that minimum is what you need to meet. Now, the landlord would like to come out a little bit ahead, but those are more of wants than needs. And so those are the items that can be negotiated. As we always tell our clients, meet their needs and negotiate their wants. And hopefully that will help both parties in the situation come out ahead on this. But it's always look for a win-win situation where they give something, you give something, they take something, you take something. So that's basically it. I want to tell you a little bit about SCORE because SCORE is here to help you. We're a nonprofit resource partner of the Small Business Administration. SCORE was created by an act of Congress, I think it's around 57 or 58 years ago now. With the whole idea that there's a lot of people out there who have business experience and who would like to help other people in business. And by the way, if you ever wonder where the word SCORE came from, it's an acronym which is not used anymore because it's antiquated. It stood for Service Corps of Retired Executives. And the fact is, we're not all executives and we're not all retired, so we're just SCORE. But that's the way it started, with the whole idea that we're going to volunteer to help people. And if you need help putting together your business plan for the landlord, please come and see us. If you need help in how to crank back up the business of starting it new, we have people who have worked out some programs for that as well, and they'd be glad to sit and talk with you. We are going to begin doing classes and mentoring in person in August. Maybe some in July, but definitely by August we'll be doing that. A little bit more about SCORE. What we provide is one-on-one mentoring, workshops and seminars. The mentoring is all free. Some of the workshops we charge for because we too have to pay rent. We have had a nice deal with our landlord. They reduced the rent by about 30%, but it's going back up to regular amount next month as well. Everything is confidential. It's free. As you can see by the numbers that have been sent out by the National SCORE Office, we've served over 10 million people since 1964 when this started. And by the way, there are chapters all over the country. There are 5 here in the Bay Area. And we have about 13,000 people who volunteer. And here in Silicon Valley, we have approximately 70 people. They're really from all forms of business, obviously a lot from high tech because that's where we are, but everything from small businesses to restaurants to consulting businesses. So there's a lot to be gained, and we're more than happy to help you with whatever we can. And that about covers it, unless there's any questions or anything about SCORE. You see our website on there, siliconvalley.score.org. If you're interested and want to get some help, go onto the website, click on Find a Mentor, and just follow it through. You have to fill out a form. And if you do, the best thing is to be as specific as possible in the box that says, what do you need help with, so we can assign the right mentor to you to help. And Des, thank you, and that about does it.
Wonderful, Mel. Thank you very much. SCORE is such a great resource in our community. I'm very pleased that you were able to join us. One other point that I'll bring up about SCORE is that Mel was talking about having that little box and providing the details. If it turns out that there's a question that stumps the local people, Mel also pointed out that they have chapters all over the nation. And so they can link you up with someone who has very specific information about your specific case. They can actually connect you up with people to provide that level of detail. So they're a great organization. Another great organization, which I'm pleased that we're partnered with, is Start Small, Think Big. And Gray Torrico is going to provide you with some information about the great services that they offer to small businesses as well.
Thanks, Des.
I'm big.
Can folks see my screen?
I can, but it's a picture of me.
It's a picture of you.
Well, yes, I'm not seeing your, there we go, your slide presentation. Much better. Those are much prettier people.
That was just to make sure that folks were awake. It's just really what it happened. I want to make sure that folks were just there. So anyway, thanks so much, Des, for the introduction. So I wanted to talk a little bit about Start Small, Think Big. So my name is Gray. I use she, her pronouns, and I am the West Coast Community Engagement Manager for the organization. And so I'll talk a little bit more about the organization before I introduce Rachel. So we are, oh, give me a second. There we go. So we are a nonprofit organization based in New York, but we have offices in Oakland and in San Jose. Our primary focus is to support small business owners like you and connect you to free financial, legal, and marketing services. And we do this in different ways. I'll share a little bit about what that looks like in our network of partners that actually include Cooley, where Rachel's from, where she's from, and the ways that we support folks. We also work specifically focused on small business owners who, are within communities of color generally, though we obviously support everybody. We really want to prioritize folks who are Black, Indigenous, people of color, women, immigrants, disabled veterans, et cetera. And so we want to make sure that we're uplifting folks in these communities as we continue working to obviously recover from the pandemic. So a little bit more about how we do this work. So we connect small business owners to volunteer lawyers, financial professionals, and marketing experts across a different array of networks. For example, in the legal realm, we generally work with big corporate firms who generally practice transactional corporate law, like lease negotiation and review, and we connect you to them. And so it is our job to make sure that we are assessing your needs, the needs of your business, which obviously will ebb and flow dependent on the current moment. And so as you think about working with us, we definitely want to be supportive in whatever you need currently. So these are some of the ways that we work in an array of different fields. We have 3 different programs, and so you'll see the different ways that we do that. I'll keep going because I really think that Rachel's presentation is why you're here. So I want to make sure that I get to that as quickly as possible. So again, just a little bit more about the different small business owners that we serve, just in terms of the numbers. 95% of our small businesses are person of color or women owned. 49 are located in underserved communities. About 50 or about half are service oriented businesses, et cetera. So just in terms of, who we are and who we serve. So moving forward here, again, just COVID, I'll skip over that. I think we all are aware of how COVID has impacted our lives. And of course, how that impact has landed on businesses specifically. And so just in terms of how we've shown up, just by the numbers, you can take a look at that. And I will, Des will most likely share this information after the fact. So I'll spare you all of the details related to these numbers, and you can have that to review after. So in terms of, how you actually access services and a kind of an FYI and a plug, so that you know that we're here to support you whenever you think that you are ready to, move forward. We are looking at business stage businesses, generally operational businesses. And so these are businesses that have met a threshold of at least $500 of sales in the last 3 months. So this is not monthly. This is in the last 3 months that you've got $500. And we are hoping that, hopefully by now with the reopening happening, that you are able and are able to kind of push through your sales of your products or services. However, we understand that should, the COVID impact still, be remaining in your business, we can consider anything prior to March of 2020. And generally, we're also looking at low to moderate income business owners. And so we're looking at a household income that is generally less than 500% of the federal poverty guidelines. When you look at our application, all of this is actually pretty fairly clear to you. It's one of the first things you see when you apply for our business, for our services. And so I definitely wouldn't take notes. It's all there for you. And I'll share that link as soon as I'm done so that you can see whether or not you qualify. So definitely take a look at this. And should you qualify, you receive services for a full year. So for a whole year, you receive all of the services that I've just shared, financial, marketing, and legal. And you can, have your, kind of your pick at all of them, or one or the other, or however many configurations you want to figure that out. And then after a year, you can reapply. So there is definitely the ability to do that. And there isn't a maximum number of reapplications. You can reapply as many times as you qualify. So it's pretty simple from there. And in terms of just, we added this slide recently as more and more folks are starting to ask us what this looks like. We share the application with you tonight. After you apply, our client relationship team would conduct your eligibility verification and then schedule an intake with you. An intake is done virtually at this point. I don't know when we're going to be back in the office, but it really doesn't matter at this point. We can do all of this virtually with you. Then we determine and assess your needs and then set up all of the referrals that you would need to move forward with the program. And then you have access to this for 12 months. The city of San Jose has a specific unique link that we use with them. And so I will share this in the chat so that we can track if you're coming from the city as a referral, we can track that for our purposes. And then obviously you can receive the services. The These are FAQs, particularly for folks who are looking to have, the intake in another language. Currently, we are able to do Spanish language accessibility. Unfortunately, right now, that's not the case for Mandarin or Vietnamese. We hope that that's happening soon, but just to be, forthright and honest, that's not something we have capability for. But do let us know. We may be able to work with interpreters or family, friends, relatives to figure out some of those pieces. We also work with undocumented business owners. We don't preclude anybody who may be undocumented. So just so you know, your status does not preclude you from our services. So lastly, this is just our resources, just basically a slide of all of the links that are most important to you. And then finally, my personal information in case you have any questions after today, and should you want to reach out, feel free. So with that, I'm excited to introduce Rachel Boyce from Cooley. I'm going to stop sharing my slides. I think you've got it right, Rachel, with your slides.
I do. I think so. Do I? Is it my screen? Okay.
Looks promising.
Awesome.
It looks promising. Funny. Let me just get this into
I'll just take a quick moment before you get started. If you have questions, members of the audience, I encourage you to use the Q&A function. That will allow everyone to see the responses that we give to you. If you use the chat function, it's just between the panelists and you. Whereas if the Q&A, we can answer multiple questions at the same time. So please use that function. In the event that Rachel's not able to answer that question as she goes along, we'll have an opportunity at the end of the presentation to get into some of those. Sorry about that, Rachel. Thank you very much.
No worries. Thank you so much. And thank you, Gray, for that really kind introduction. So as was mentioned, my name is Rachel Boyce, and I work at Cooley LLP. It's a pretty large law firm, and I specialize in real estate and finance. And I've been doing it, I'm a mid-level now, so I've been doing it for quite a few years. Today we'll talk to you about quite a few things, but just wanted to start this by saying that over the past few months, as of March, well, more than a few months now, over a year, as of March 2020, the firm and the real estate group in particular, we've been doing a lot of work in providing assistance to small businesses and individuals with the pandemic in various different ways. For me as a real estate attorney, this has taken the form of helping small businesses negotiate their leases, helping them to the extent that we can with their PPP loan applications, helping them with abatement and termination. There's just been so many different things we've had to step in and just help businesses with over the last year now. I can't believe I'm saying a year has passed, but it has. And so really happy to share this information today, specifically about leases and generally the experience that we have and things we have learned over the last few months in helping small businesses. So today we'll talk about reviewing your lease and the things that are really important in your lease that may help with negotiations. The government orders, Des spoke about it in the beginning with specific to San Jose, but I will cover a few other Bay Area counties as well and cities. And then landlord negotiations. I'll try not to repeat a lot of what Mel said, but definitely we've been super involved in the negotiation process. So happy to share information there as well. And so, as I mentioned, COVID-19 as of March last year, the pandemic has resulted in quite a few concerns from small businesses seeking relief from payment obligations. I think once things hit last year, the main concern for many small businesses was what can we do? How can we do it? And how we're going to pay our rent, right? Like rent is usually one of the major, probably biggest expense that small businesses have to incur. And so that's the fear when there's a pandemic that tells you that you can't open your business or you can't operate, right? Some of us have been fortunate to continue our work from home, but as many of you would know, that's not practical when you're a salon or a supermarket or retail, right? Like you just can't pack up your shop and go home. So, there have been lots of concerns there, and lots of government orders have been provided over the last year or so. But it's really important to know that the relief which these government orders have provided is not always automatic, right? In some cases, it requires you to have a conversation with your landlord. In other cases, it requires that some type of submission be made, whether it's attesting to the fact that you have been significantly impacted or putting something in writing. But not all of these orders which have provided relief are equal and provide relief in the same way. And even though the moratoriums are coming to an end, I think we recognize that some businesses are still very much struggling, or still even in a much more difficult position than they were a few months ago, right? So we have some businesses who are able to reopen and figure things out because of good negotiations with landlords, and there are others that are just really, they just can't. And we can talk more about that as well. Landlords, I think, as Mel kind of alluded to, have responded in many different ways. And we can talk more about, some of the things you want to share with your landlord and how they've been responding generally. So first, the lease, right? And whenever clients, and we have clients on both sides, right? So we do have clients who are tenants and we do have clients who are landlords. I work mostly with tenant clients, but we see it on both sides. And then as an exit strategy, sometimes what we see is that some of our tenants become sub-landlords because they can't keep the space or they don't want to. And so they are subletting it to another tenant and therefore becoming landlords. So we've been seeing quite a few things on different sides. But whenever a tenant client comes to us and they're looking for relief, the first thing we say is go look at your lease, right? Send us the lease and let's see what language is in there that might be helpful. The issue is, the list of things or the negotiations are by no means exhaustive, but whenever there is something in the lease that provides direct language to a termination or rent abatement, it's the best shot you have, right? The landlord can't push back on it. I mean, they can, but it doesn't take away your right. The landlord can't argue against it. They might regret agreeing to that language in the beginning, but the lease is the place where you have the most secure language as to what can and what cannot be done. And then you can go from there. I mean, unfortunately, lots of leases are landlord friendly, and that's how they're drafted. And so in some cases, unless you have an attorney who's negotiating on your behalf from the beginning, because what happens is that lots of small businesses, they enter into leases on their own, right? They just want to start a business, they get a lease and they sign away. And that's where, start small, think big. And some of those other organizations are really helpful with partner in small businesses with attorneys that can help. But unless you have an attorney who's in there negotiating from the beginning, your lease is likely to be very landlord friendly and not provide these type of termination rights and rent abatement. So we'll talk about some of the key provisions that an attorney would usually negotiate for you, or that might just be there if you were fortunate and got a pretty decent lease. One of them is interruption of services, right? And many leases would have a provision where the landlord will abate your rent under certain circumstances, such as an interruption of service. And how we've seen this come up is a case where it's a multi-tenant building, or it's a building that perhaps has a lobby, and the landlord is providing other services outside of just the lease space. So let's say, for example, the landlord is providing cleaning services, or there's a mail room for packaging, or there's even like coffee and tea set up, some communal space that all the tenants share. What we found is that during the pandemic, lots of those services were removed or reduced because to the extent that office space or retail space was open, it was only to provide access to the premises that was allowed or permitted by law, right? And so if it wasn't one of those, and most moratoriums and government orders provided really specific areas or specific businesses that were allowed to open, but in those cases, other things were not. And we were able to use a lot of that interruption of services language to say to the landlord, well, hey, all of these services which were contemplated, we're not able to get. And so for that reason, we want at least, if we can't get an abatement of rent for the period of time that we can't use the space, at least let us get an abatement for the services you're no longer able to provide. And sometimes it's just a direct negotiation with that. Other times it's coupled with, okay, we can't get any other abatement, but at least give us back the money for not being able to use the space. Then there's force majeure, right? Most leases will have a force majeure clause, right? Again, depending on how it's negotiated. The problem with this clause is that usually it's very landlord favorable. And even if there's a mutual force majeure type of relief, the lease would probably say that there's a carve out of rent obligations. So what that means is that even though there is this force majeure or acts of God or some event that has happened that has now prevented the tenant from using the space, your obligation to pay rent continues, right? This is again a place where we would try to negotiate, but to the extent that this clause or this provision was not negotiated, you can't just say to the landlord, oh, this is force majeure, it's not our fault, we can't use the space, and so therefore I'm not paying rent, right? It just doesn't work like that. To the extent that there is this provision, 98% of the time, there will be the exclusion of rent. But it's really important to read the lease, right? I would say of the tons, maybe hundreds of leases that I've seen and negotiated over the last few months, specifically with respect to helping small businesses negotiate their leases, there were actually a few of them that had a force majeure provision that did not have the rent obligation or the rent carve out. And so that was a perfect opportunity to present to the landlord the language, right? Clearly that was not the landlord's intention, but it's in the lease that if we can't use the space because of this force majeure event, we don't have to pay rent, and we're sorry if you didn't intend it that way, but this is how we're going to read the lease, right? You can sue us for it, but this is the approach we're taking. And in very few cases it worked, right? Also, personal guarantee. I know tons of tenants are really are always concerned about this because for a lot of small businesses, there probably will be a personal guarantee associated with the lease. When I'm helping tenants negotiate, I always try to tell them push against it if they can. It's much better to have a higher security deposit or pay down more or find some other way to prove to the landlord that you can pay this rent than to be personally liable. Because what that means is that the landlord can go after you, the personal guarantor, to meet these obligations, and you don't want that. I mean, there are some protections in California which would, prevent them from taking your whole house and your car and every single thing you own, but it's still a very stressful thing. So be really careful there. But to the extent that you have a personal guarantee as part of the lease, know that that is something that the landlord can use to try to go after you. And then there's co-working agreements, right? Thinking WeWork, Knotel, some really small businesses tend to prefer this flexibility. And we've seen more favorable pushback here with the extent of, the provision of services that I mentioned before, because how these agreements are drafted, they're not leases, they're membership agreements. And so you pay to use a space, and it comes with a conference room, it may come with coffee, it may come with all these different amenities. And all of these things were not able to be provided during the pandemic because of the shelter in place type orders. And so for that reason, we push back on landlords saying, well, if we can't use the space because we're not getting these services, then we're not paying the fees. And again, a little bit more flexibility than a typical lease, but something to think about nonetheless. Most leases would have a subleasing or assignment provision, and this is where I think landlords expect tenants to rely on more than giving them some type of relief. So, most landlords, and as Mel mentioned, they have been impacted too. They're trying to negotiate with their creditors for forbearances and all these other different types of, relief that may help them, but they are not necessarily expecting to share the burden or the brunt of what the tenant is going through. It's unfortunate, but it's a sad reality. And so they're hoping that tenants can be creative in how they figure it out. And so some landlords will directly say to tenants, like, why don't you try to sublease or assign the space? And that's an option. I mean, it might work out cheaper to assign the space at a discount because no one is probably going to pay you the price you got in for in 2019 when we were at the top of the market, right? Like, things have definitely shifted since then, but it's definitely an exit strategy that tenants can think about if they're at that place where they're like, we can't do this. We don't want to keep the space. We don't want to stay here anymore. Think about, providing the space to another subtenant that could potentially take over your obligations. Lease termination, in rare cases would a lease have this. And whenever it does, it probably would be tied to some type of termination fee. But if you have it, again, I've seen it in leases where, tenants just gave up. We don't know what to do. And I'm like, send me the lease. And we go in and we find a lease termination and they are so relieved, right? Again, it's rare, but to the extent that you have it, it's like winning the lottery and trying to get out and negotiate with the landlord. Frustration of purpose and impossibility. These are two common law doctrines that lots of tenants have been trying to push, mostly large tenants, and mostly them because they're the ones that can afford to push these type of arguments, right? Like, you're not going to be able to just submit this to the landlord and think they're going to, give you a get out of jail ticket, right? Or a free ride. These doctrines have to be negotiated in court. And because they have to be negotiated in court, they attract significant, very high legal fees that small businesses would not even want to incur, right? If you're not able to pay your rent, you're not going to be interested in pushing these doctrines. But why they're important is because they're going to set some type of precedent for what we would follow, right? We're still tracking cases to see what would happen. Victoria's Secret was a big one that did not go in their favor. So the court was like, no, we're not going to agree with you here. But it's still heavy in litigation, right? And because the courts have been closed to a lot of these issues over the last few months, we don't know, or a lot of these cases have not been decided yet. So definitely something to keep tracking so you can see, well, if it happens for that particular company, it could probably be applied to our case. Insurance, almost every lease should have insurance requirements. And it's really important to even consider, for those of you that might be contemplating new leases, to consider business interruption insurance and how important that has been over the last few months. It's good for those of you who have insurance already to see if business interruption was included in your particular policy. This is really important because your insurance company is not going to tell you, like, they're not going to call you up and say, hey, you have business interruption, come talk to us. You have to assert that right, and you have to fight for your claim, because that's just how insurance companies work. They're not going to offer up the money to you. But you should definitely look into your insurance policies to see if you have business interruption. And in some cases, that could be applied to a lot of the money you've lost because you could not operate your business during that time. And then, we spoke a little bit about the government orders and particularly the eviction moratoriums, which has been the thing that I think this is the one thing that has perhaps kept landlords under a little bit of control, because they're also suffering, all right? And the strongest thing that a landlord can use when a tenant isn't paying their rent is an eviction notice, right? Because that gets the tenant's attention. If the tenant doesn't want to leave the space, they're going to be concerned about losing their space, losing all of their property within the space, because the landlord can decide to just seize it and not allow you access. And also, evictions go through the court system. So if the landlord ultimately in the end prevails, this is public record, right? So future landlords can be able to see that you were evicted, and nobody wants that, right? Your business doesn't want that, because it's like something you have to explain, and it could impact your business moving forward, right? Your credit worthiness, as we will call it. So because of these moratoriums, landlords have been under a little bit of control and not be able to just evict tenants from their commercial spaces. But it's important to know that they're temporary. They're not going to go on forever. We've seen, since March, we've been seeing extensions. I think the last time we did this presentation, there was a moratorium which was terminating at the end of March, and now we're seeing it at the end of June, and then others are going on till August. And even after the moratorium expires, a lot of them provide grace periods for 6 months or 12 months as to how long tenants have to pay. So this has been the one tool that has really helped businesses figure it out. But once they're expired, then you'll have to figure it out, right? And the moratoriums, tenants will have to meet certain criteria. So again, proving substantial loss of income, proving that you haven't made a certain amount. It depends on city and state, but these are all things that you have to look into. And then in many cases, and this is the one that gets a lot of tenants, is the affirmative relief, the affirmative request from the landlord. So you can't just decide, I'm checking the boxes of substantial loss of income, and okay, I didn't make this amount of money, but you have not affirmatively spoke to the landlord and say, I am not paying rent because pursuant to section 12 of whatever moratorium or whatever government order, I qualify. Like, the landlord has to be provided with that information. And in some cases, evidence of it, right? Like, an evidence could be anything. It could be a statement that shows that you haven't made any money. It could be, we've been really creative. We've submitted orders to landlords saying, this order says they can't open their business because they're not one of the businesses that were prohibited. And because of that, it's obvious they've made no money, right? Like, they couldn't open. And so unless they're doing something illegal, whatever. So there are not a lot of rules or specifications as to what your affirmative request looks like, but there is a request that's required, and it's really important because a lot of tenants miss it. Also really important is to check the moratorium in the city and county that your business is located, right? This is a big one too. So you'd have a tenant who lives in Oakland, but they have a business in San Jose. Well, that's San Jose, where your business is located, may have slightly different requirements, and that's the order that governs your business. It's not where you live. Because you may have a residential moratorium that you're also reading into, which is important. But again, that doesn't help you for your business in San Jose. So be really careful. And even if a tenant does not qualify for an applicable order, applicable government order, just know that direct negotiations with your landlord can offer some relief. And actually, in cases, we tell clients, even though you have rights under these moratoriums, starting off or coupling those rights with negotiating with your landlord is really important. Just don't try to piss them off like, I have a right, I'm not paying rent, because the landlords are aware. They have attorneys too. Most of them, some of them pretend like they don't know what the moratoriums say, but most of them do. And so trying to couple your rights with negotiations so you can show the landlord that I'm not just here to run away and not pay, but I do care about what you may have lost as well, can lead to a better result. This is just an overview of local ordinances. I'm not going to go over this in detail, but it just shows that there are differences, right? There are differences in the expiration of the moratoriums, in the criteria, and in the general protection. So to the extent that you have access to this presentation, definitely feel free to check it out, just so you can see some of the differences there. And so we're approaching the end of moratoriums, right? Or the reopening, more or less. I think June 15th, less than a week away, we will have a fully open California, I guess. I don't know, we'll see. And so that comes with changes in the orders and changes of the things that would govern how businesses reopen, right? And so what would happen, right? To the extent that the moratorium has expired, again, you have to check your moratorium to see if there is some grace period. Lots of them do, not all of them don't. there are differences. But once that grace period has expired, tenants will be required to pay back what was due and unpaid during the moratorium period. That's just what's going to happen. And so that's going to be a decision you have to think about, right? How will that repayment happen? Is it going to be a lump sum? Are you going to try to negotiate with the landlord to repay the rest of your future rents with a little bit of that back rent to catch up? It can look like different things for different tenants, for different landlords, but it's going to be owed, and it's going to be due and payable unto the landlord. Landlords would be able to commence eviction actions, and this is the thing that has stopped them. And so once the moratoriums have expired, they'll be able to do that. So if your plan is to continue operating at the space, then you have to, take note of that, because if you're not paying rent, the landlord can't evict you. Just a few considerations about commercial leases in general, because I think at times there are lots of misconceptions. Note that there are very few statutory protections for commercial tenants, right? It's not the same as a residential lease. Residential leases have lots of protections, protections on all kind of things, habitability and all these other things that we just don't have in commercial leases. And so, landlords don't have a duty to mitigate. They don't have all that. And so lots of times tenants call and, they're upset because the landlords are not being cooperative or not trying to help them. And they're like, they have a duty to mitigate. And I'm like, hold up. That is fancy language for your residential lease. That just doesn't work with commercial leases. Sorry to disappoint you, but that's just what it is, right? And so I think there is this understanding of this is how it works with residential, but it's not the same with commercial, unfortunately. And so you have to be very careful to review your lease and know, and this is also really important for you negotiating your leases, right? Because whatever you want to get from the landlord, it has to be documented in the lease, because you can't come back 5 years later or 3 months later and say, well, I have a right to this. Like, that's just not how commercial leases work. Landlord negotiations, and these are my last few slides, and I think I can go through these really quickly because Mel already went over how these landlord negotiations work. But generally, before speaking with your landlord, I said it before, make sure you review your lease, right? You want to know what rights you have, because these rights are going to help you negotiate, right? If you don't have a termination right, if you don't have an abatement right, it's harder to have these conversations with landlords. And also knowing the amount of time left on your term, right? If in 2020 or in 2021, your lease expires December 31st, 2021, the conversation with your landlord is different from a tenant that has 10 years or 5 or 6 years left. Why? Because the landlord knows that your lease is coming to an end soon, and the market is down for retail and office and salons and all these things. And so your negotiations with them would be in terms of, along the lines of, well, I can stay in the space if you reduce my rent, or I can stay in the space if you forgive my rent, right? Because your term is so close to being at the end. It's a much different conversation and a much different exposure. Like a tenant who has 5 years left has 5 years of exposure of rental of rent that you have to pay to the landlord. So it's quite different. Again, check your applicable state, county, and eviction moratoriums to make sure you know your rights. While many Bay Area counties and cities have these rights, some of them don't, right? And so if the landlord, if there's no rights for these government orders, the landlord can just be like, well, I don't owe you anything. And then really critical is to think about your best case scenario, right? Like, understand your business. What is the potential future of my business, right? Does it make sense to terminate this lease or renegotiate and keep the space? And as Mel had mentioned, sometimes keeping the space may mean finding a smaller space in the same complex, right? Because now you know that some of your business operations can be done online, but you need office space for meetings, or you need space for certain things. So talking the landlord through, can I get a space in this complex, but make it smaller? And so they get to fill up space and not lose the tenant completely. Do I prefer deferrals now, or do I prefer them over the life of the lease? It depends on how your income stream is and the success and, the movement of your business, right? These are business decisions, but things you need to think about. And what other concessions would help my business, right? Like, okay, the landlord might not be comfortable with giving you a full rent abatement or deferral, but there are other things that would help your business, right? A reduction in your operating expenses may help since you're not using the space. It could be renewing your lease at a more favorable rate, so 3% under fair market value. There are other things that you can approach your landlord with that is not strictly, I want a rent abatement, because landlords in some cases don't want to hear that. And if you have the means, retain an attorney. And even if you don't have the means, as Gray mentioned, and there are other organizations as well. I work with Start Small, Think Big, and we've been helping them, with these small, bite-sized little legal consultations on how to talk to your landlord. So definitely try to get some legal help. It's important to be creative and to be flexible. A tenant who has a proposal to a landlord that only requires termination is not going to be as successful as a tenant who's thinking about, well, can I just have a month break or 2 months break or something, right? Like, just don't go to your landlord and say, I want out, because the landlord in this market, which has been dropped also, will probably not receive that very well because they're stressed about paying the mortgage, right? Only use the eviction moratorium as a negotiating strategy. It doesn't have to be a right. I mean, you have a right to it, but don't just go to your landlord and say, this is my right and I'm taking it, because if the landlord, if you are negotiating with the landlord, you might get a better deal. There are some landlords that have reached out proactively and provided relief to tenants. And if you're a good tenant and you're paying rent and you can, guarantee that continuing to be in the space would be beneficial to landlord, they might want to work with you. So try to use that as a negotiation strategy, but not as your right and just walk away. And then coming to a deal with your landlord is preferable than relying solely on the moratorium, right? So try to find some middle ground there. And then lastly, just giving some examples from what we've seen from landlords generally. Usually when you reach out to them the first time, they say no. It's just like, hey, can we? No, they just say no. They don't even let us finish the sentence. But, you push back, right? A little bit of persistence will really help. And in your persistence, try to be transparent to the extent that you can, right? Like sharing with the landlord, some of these things are obvious, but other times they're not, right? The landlord might assume you have a different income stream. They might assume that you're getting PPP. They might assume that you're getting some type of, government relief. And so it's not their business to try to figure out what you have going on outside of the lease. So be persistent and try to talk the landlord through what is really going on so that, at worst, you can try to pull on their heartstrings and see if they have a conscience. They might have one and still say no, but it's better than just walking away and giving up. Requesting extensions in exchange for abatement, because the landlord would think, okay, having this person or this entity in my complex for longer is better than not having them at all. And as I mentioned before, forgiveness of operating expenses, parking fees, all these other things that wouldn't have been used doing shelter in place could be good things that the landlord might be willing to give, because it's true, they've saved some money there. And yeah, well, I guess that was my last slide. So definitely would open it for questions. And I know Des has been tracking those questions, and happy to answer those.
Rachel, great presentation. Thank you so much for all the in-depth information you're providing and all the great ideas that you've got there for ways to approach the negotiation, because clearly that's an important element to be thinking about it in your interactions with your landlord, because the reality is as Rachel pointed out, a lot of them are in the same boat. They haven't been able to make money in the same way. If you haven't been paying, some of their other tenants may not have as well. And so how are they making ends meet? And are they looking at the end of the moratorium as being the salvation for them? So I'd like to encourage those of you who have questions to put them in the Q&A section. We'll walk through those and make sure that we address any of the questions that are raised in that area. I did have a question. So in Santa Clara County, and I'll put this to Mel initially. In Santa Clara County, the ordinance basically says that you have 6 months to pay your rent and your back 50% of your back rent, and then another 6 months to pay 100% of that. The way it's worded, it seems very broad. I'm wondering, as you're thinking about the negotiation, or as I was thinking of negotiation as a tenant, can I use the fact that it's broad to say, well, look, I need a little bit more time because yes, the governor says the economy is open, but all those fearful people who are still wearing their masks are not coming in to do whatever it is that I'm selling or buying, or however, for the services I'm offering. Can you think of a way that could be used by the tenant to open a conversation with the landlord about the timing of the repayment?
Yes, absolutely. And part of it has to do, again, with the business plan saying this is how we plan to reopen and where our marketing is. But also part of that can be, you have 6 months to repay the back rent. Doesn't mean you have to pay 1/6 of it every month. Give me 2 months moratorium and I'll pay you 1/4 of it for the next 4 months. Let me get cranking back up again. And I'll be glad to show you my income statements. And if income is going up faster, I'll pay you faster. This is good because when it comes time to negotiate again with the landlord for a new lease, if he sees good faith on your part that business turned around faster than you thought it would, they're going to be more open to working with you. One of the things I'd like to say, I just want to go back to something Rachel said, which is very important. In selling businesses, when people look at their lease, I find that most of the people look at the first page. What's the rent and how long is the lease? And forget about the other 47 legal sized pages in small type. I don't understand half of them, and I read them all the time. You really have to have an attorney take a look at it, even though it costs you something. As I tell people, the landlord has spent thousands and thousands of dollars on their attorney to write it. And frankly, you can negotiate pages 2 to 47 a lot easier than page 1. If you're willing to pay the rent and say, but I don't like paragraph 37, they'll work on that. And Rachel's right, you just don't even realize what's in there and what abatements you might have. And when you can get away without paying rent because services weren't provided. Too late for those who've already signed the lease, but for a lot of people, they're going to be signing new leases or exercise an option in their lease, and that's the time to bring all this up.
Yeah, that's a good point, because it does seem like many of the businesses, as you say, their leases may be coming up. Is this a particularly good time to negotiate a longer term lease as well, in terms of lower rates from the tenant perspective?
Don't know if you'll get lower rates, but it will make the landlord more open to stretching out, having you repay it if he knows you're going to be there for 10 years. I think Rachel mentioned that as well. Landlords want to keep their place filled. That's how they make money and pay off all their expenses. And if you've been a good tenant and you keep the place filled for them, they'll work with you on it.
Well, we did get another question through chat. So again, I encourage people to use the Q&A because that's easier for the panelists to see. However, the question, and I think this will go to Rachel, is I rented a commercial building and subleased a part of the building to someone else. However, that space no longer meets the city code. My landlord is requesting me to pay the rent for the entire building. Is this possible? Presumably the sublease was voided by the fact that the subtenant was not able to use that space. Any thoughts, Rachel, on where the inquirer could go or how they would approach this?
Yeah, I'm happy to give general thoughts on this. So, the first thing generally with subletting is that the original tenant is not off the hook, right? That only happens in an assignment, right? But assignments are hard to get from landlords. So what it means is that whether the subtenant pays the rent or not, whether they stay or not, whether their use of the premises is voided or not, the original tenant is never off the hook, right? They are always a source that the landlord can go after if it doesn't work out down the line, whether it's, the subtenant or other further subtenancies. So all that to say is that the original tenant was never off the hook. And so the landlord always had some type of recourse against the original tenant if something went wrong. And it looks like it has, unfortunately. As to the subtenant, I mean, if this is a space that was zoned or approved for a particular purpose and it no longer is, then legally it shouldn't be used for that purpose, right? It's unfortunate, but that's just what it is. But the landlord does have a right to now ask, and always did have a right to go after the original tenant for the full payment of the entire complex.
And I suppose that the person who wrote their lease might in fact be able to hold that. That is to say, the person who's asking the question, who has a lease with a subleasor, that the document that they signed with their subtenant is actually where they would go for an indication about whether or not they could continue to expect payment from the person who, the city rules have changed.
Yeah.
Does that mean they're off the hook too?
Yeah. I mean, the subtenant in that case can decide that, well, I'm renting. That's a perfect example of like frustration of purpose, right? Or because they've entered into a lease for this particular purpose to use it for this reason, and they no longer can. And so they might have an argument for no longer being able to use the space in that way. And so they don't want to continue paying rent. The interesting side of it from the sublessor is sometimes, and it depends on how the lease is drafted, the sublease is drafted, the payment of rent is not tied to the use of the space, right? So they could say, well, this was the use, but this is not what you're on the hook for rent regardless, right? This is just what we agreed to. So impossibility doesn't apply, force majeure, all these other things that would cause you or give you a right to walk away wouldn't apply right here, and you have to continue paying. So this is something that would ultimately probably, if they can't agree, be litigated, because there's strong points on both sides, right? In one case, the purpose or the use of the space has been frustrated. They can no longer do it because of some change in the law. And on the other hand, the subtenant or the sublessor is saying, well, hey, you are responsible for the space regardless of how you use it, right? Or just change the use, do whatever.
That's right. Pivot your business model. Come on.
Yeah, figure out your business model. And some leases would have that language, right? Like it would have the language that the landlord or the sub-landlord is not responsible for any change in law with respect to the payment of rent.
So one of the elements of the Santa Clara direction is that the landlord, as part of any eviction process related to this, will need to actually, before initiating an eviction, be able to provide a written document that says, here are your rights, tenant. And among those are that you can tell me that you have been impacted by COVID. Do you know if any of that will change after the end of the eviction moratorium, or will they simply be able to say, yeah, I'm done with you, you're leaving, and that's, I don't have to give you any justification after the end of the eviction moratorium? Whoop, I'm sorry, you're muted.
I was muted. Yes, yeah, that's an interesting question, because so what the moratoriums are doing is also requesting this type of affirmative request from the landlord to inform the tenant that, they of their rights, to inform them of their rights and try to negotiate or let them know of, their rules they're under. But how it works generally for evictions is that the landlord can't just decide, I'm going to kick you out, right? There is still a process. First of all, the landlord can't do that. I think landlords sometimes like to make tenants believe they can just do that, but they have to go through the court system. They have to, there's a 3-day notice to quit. They have to submit a complaint. The tenant has to be served. Then they go to court, and then there's a hearing. Sometimes the attorney, the tenant may have a pro bono attorney who helps them. And so there's still a process. So even, I mean, it's always in the landlord's best interest to start there, but even if a landlord doesn't and decides, I'm just going to go after you, the way how the system is set up by the 3-day notice to quit and the tenant being served and the complaint and all this would provide the tenant with the notice that they need. And at any point, the tenant can decide, okay, here's your money, be done with it. As part of the negotiation, here's your money, drop the case. And
Right.
yeah.
There is another question that came in through the chat. Again, I encourage people to use the Q&A function. That makes it more, there's somebody who's using the Q&A function. Yay! Let me continue with the chat here, which is that in this case, it appears that the person is a landlord. Are you able to answer questions about residential eviction moratorium elements, Rachel?
With limitations. We don't do a lot of residential. We
Well,
do mostly commercial, but
I'll read the question off and then you can make the decision as to whether you're having that. So
sure.
It says, I rent to Section 8 client. Tenant is not answering their phone and has not paid their rent from June 2021. What to do?
June 2021, like 10 days ago?
That's what it says.
Okay, yeah. Yeah, I mean, you're right. I don't have a ton of knowledge on how the residential moratorium work because I just haven't been dissecting them as much as I've been doing commercial. But
Right.
I think if the landlord has concerns with the tenant not paying rent, it's the same process, right? They can go to court, they can serve them a notice and file a complaint, have the tenant served, and there might be a court hearing. I don't know. So there is also a residential moratorium. And because of that, they might not be able to serve notices right now. They might have the same, period, like the 6 to 12 months. And I think for residential, actually, it might be more. Some of them are up to 2 years because they're just more protections, especially with a lot of the homelessness and stuff we have in the Bay Area. The residential moratoriums have definitely been more protective for tenants than commercial. But once all of that has expired, then they can go through the same type of, civil procedure process of serving someone for a lawful detainer for remaining in the space. But I'm not sure, I can't say with certainty that they're able to do that right now because I'm pretty sure residential moratoriums are still somewhat in effect or at least still in their period after,
Yeah, and I'm not even an attorney, so anything I say is not a legal opinion. But I would observe that the residential protections are much more robust than they are for commercial tenants.
Always.
So,
very much so.
So the person who's making this inquiry should probably refer to somebody who works in residential so that they can understand the extent of their rights as landlords. Also, the fact that it's a Section 8 client probably also makes it more complicated. So talking with someone who has specific information in that area would probably be good. And Gray, I'm assuming that as this is residential, that it's unlikely that you guys would be able to provide assistance in that area. Yeah, so probably good to refer to an attorney of your own. Look at this is great. I hadn't realized how many landlords we had in the audience. So I apologize that most of the content is aimed at the tenants, but appreciate you guys sticking with us. So Mel, this is a question that actually may pertain to you. It's in the Q&A.
Yeah, I've looked at it.
Okay. Do you want to? Why don't you read it out for those people who are not able to see it?
The owner of a sports bar at which this person had been managing decided he doesn't want to return to business and agreed to sell liquor license, DBA, and equipment and subletting the space to me. Now the question becomes the question with the landlord, who's required to pay the back rent and must the landlord fix things? First thing is, if you are buying the liquor license, you do have to have a location in which to put it. So that's the first thing. Secondly, I would go to the landlord and just say, look, this guy's gone. Let's you and I work out a new lease. If he's going out of business, he's probably not going to be able to pay you what he owes you anyway. I'm willing to sign a 5-year lease with options, a 10-year lease with options, and then discuss the work that has to be done according to the lease as far as repairing the roofs and so forth. But I would not look to sublet. Well, there's two things. One would be subletting it, and one would be getting an assignment of the lease. I wouldn't look to do either one of those. I would look to get a new lease and make the offer to the seller contingent upon getting the new lease. Then go through all the things that Rachel and I talked about when you sign a new lease, what you look for and what you're careful about, and read page 47 as well. So
just one thing, because Mel's being shy and not bringing this up. One of the things that SCORE can also do is help you evaluate the value of a business.
Absolutely.
So in that the owner of the sports bar is trying to tell you, hey, this is the value of it. But over the last year, I bet you that sports bar has not brought in a whole lot of money.
Right.
And so then the question is how much value do you put on those pieces that you're able to purchase? Does he have a robust database of his clients who all answer emails, or is he just hoping that the location is the value that he's, and the liquor license are what he's providing to you? But if you can, as Mel pointed out, if you can negotiate a favorable lease with the landlord, well, maybe the value is different. And Mel and the other people at SCORE can help you look at that carefully and come up with a quantification of that. So you can say, $145 million for your business? I'm not sure if that's warranted.
In fact, we just have, a national SCORE has given us a new tool to do that, in which we have access to the business reference guide, which has rule of thumb evaluations for, I don't know, maybe 200 different kinds of businesses. It's not an exact, but it lets you know if you're in the ballpark.
So definitely, don't forget SCORE. They're beyond the lease question. They can help you with the business model as well. All right, Peter Chen has asked, my tenant just turned in the key and left last year. He has a 4.5 year lease left when he turned in the key. What can the property owner or the landlord do? And I think that's Rachel.
I think the first step will be trying to find him. Like, where did he go? I don't know. But I mean, more practically, the disadvantage that landlords are facing is tenants potentially going out of business, and they going out of business without, the landlord having a large security deposit or a personal guarantee or some other way to get the money back. And so what's happening is a tenant that walks away is probably also walking away from his business. And so you can sue him, you can do provided that the moratoriums have expired and the time is right to do so, you can decide, okay, I'm going to serve notice, I'm going to sue him, blah, blah, blah. But, landlords for the most part are unsecured creditors, right? And so 100% from zero is zero. Like, there's nothing to get from these tenants if there's nothing that they have, right? Once you go through the whole bankruptcy or, the whole process of trying to figure out putting value to their assets and how these could be assigned to the landlord to recover, it's not even worth your legal fees. And that's really unfortunate. It's really sad because, as Mel and I have been emphasizing in Des, like, we've seen it on both sides. Like, we know that tenants and landlords equally have been hurt. The thing is that tenants who are walking away, or usually at the end, they have lost the entire business, and there's just nothing to go after. And you can find them, but if they were not a personal guarantee, you can sue the business, but the business is now has no value. So I think while there's no duty to mitigate, the fastest thing for landlords is just trying to, get that space occupied as quickly as possible to start seeing if they can recover, some of that money. You don't want to wait 4.5 years and try to get him, because he's probably not going to have anything left for you to go after 4 years from now. Sorry.
Yeah, it's a quandary. This pandemic has hit everybody. So I really appreciate you guys sharing your insights and things. Mel, just one last question for you. one of the things that Rachel mentioned was the idea of a business going bankrupt. Is that something that SCORE can help people evaluate the pluses and minuses of making that, that hefty decision?
Not really.
No, okay.
That's not really something we get into. It is a business decision, but there's so much more that goes into going bankrupt. And for most people, if it's a small business, it's going to be a personal bankruptcy as well, because as Rachel said, they've personally guaranteed the lease. If they got a loan to start the business, they personally guaranteed the loan. So, and there's probably nothing left to the business to have much value on it. That's why a lot of times we've seen businesses that are having a real problem paying the rent sell for $10,000. But you got to take over the lease. That's the whole thing. And the only reason for the 10,000 is so the business owner can walk away and paying all his costs without having to dip into his pocket to pay to get out of the business.
That's interesting.
We are actually hosting a bankruptcy and debt restructuring workshop, and we work with bankruptcy attorneys.
Ooh,
That's great.
Great. Do you have a link yet? If you do, we'll stay on, and maybe you could pop that into the chat to make sure that'd be great. Oh, look at, there it is. You are so on top of it, man. All right, so we're at 7:30. If you guys will forgive me, there is one last question, which again came in through the chat. So last question, no more after this. Oh dang, there are two questions. All right, I'm gonna two questions. We'll make them quick. The first one is from the person who was buying the business, who with the liquor license, who asked, is it possible to ask for any of those repair costs reimbursed as possibly discounting the rent on a new lease?
Absolutely. Keep in mind, you can ask for anything. You just have to put up a good case why the landlord should do it. And the more comfortable the landlord might be with you becoming a good tenant and paying the rent for 10 years to come, the more they're likely to do it.
Yeah, one of my bosses describes himself as having the superpower of not being shy about asking for anything he wants. And I empower all of the attendees here. You adopt that superpower, because the worst that can happen is they can tell you no.
And then you're no better off than you were if you didn't ask them.
Yeah, as long as you ask politely and recognize that it may be unreasonable. All right, one last question. Can I lease out building spaces that do not meet city requirements and codes, such as not meeting structural codes or requirements? Now, I think this is a bit of an ethical question as opposed to a legal question, but Rachel, why don't we go to you for that answer?
I'm like, so I mean, I think to provide more of a positive answer, if the lease or doesn't meet city code, I think trying to conform might be easiest. It's not very easy to do, but in some cases, you can request from the particular city or county a special use permit, right? Or a conditional use permit, which allows you to do things that the particular area may not be necessarily zoned for. It's just a process, it's a request, and it takes time. So that's one thing. We've seen it. Land use attorneys are better able to get these done and know if you'll get a no or a yes right away, but it's possible from that perspective. But I think, and I don't know if that's helpful. Let me reread the question to make sure, because I want to like, what do you mean exactly by not up to code? No, I don't see it.
I think the way to think of it would be if you had a building that, let's say, for instance, was in seismically sound, and among the requirements would be that you would have to upgrade the building before tenants were able to occupy it. But if you were to lease it to someone, would you be able to make the case that, well, yeah, maybe they should have known that they had to make tenant improvements before they moved in, but they signed the lease?
Yeah, no. So yeah, I actually just reread it, and I think I know where they're going with this. So yeah, you can do the zoning thing and whatever. The city wouldn't approve something that isn't up to code, frankly. So you have to be careful generally in the business of leasing spaces that are not up to code. But with respect to your relationship with you, the landlord, and the tenant, tenants are supposed to do their own walkthrough, right? And they're supposed to look at the condition of the premises. The issue with that is that a lot of these things, there might be like a latent defect that they're not able to see at the time. And then the question is, well, who's responsible? And I think it really comes down to the negotiation of the lease. I always encourage tenants to not only ask for the landlord to put a rep that the lease is up to code, but also have a 3-month window such that if you find something after, because you might move in, you might do your as is walkthrough, but not figure out that the HVAC or something structural is not up to code. But you give yourself like a 3-month window to report that to the landlord and then make it their responsibility. So that's something you have to negotiate. If you sign a lease as is, and you don't do a walkthrough, and you don't ask for the rep, and you don't ask for the 3-month period, then you're really, it's a commercial lease, right? You don't have the residential protections that can give you a habitability pass. Like you just don't, and you'll be on the hook, frankly.
All right. Well, we'll hope that information is useful both for the landlord, who may want to think about whether or not that's the direction they want to go into, but also for the tenant to know that in some cases not everything is visible, and having the pieces in the lease. So it goes back to the whole question of look at your lease, not just the first page, as Mel pointed out, but all 47 pages of it, because it makes a big difference. But you do have people who are in your corner, so to speak, and the panel has done a really good job at raising that, hopefully raising your awareness about what's possible and what you might want to be looking for. So I'm gonna, whoops, I thought I was gonna share my screen, but of course, there we go. All right, just this last bit here. So I don't know, are you guys seeing my screen now? Yes, okay, great. All right, well, so again, thank you guys for joining us. This has been the Commercial Eviction Moratorium. What are you guys seeing now? I have a feeling I've left all sorts of stuff all over the screen. So anyway, long and the short of it is thank you for joining us for the Commercial Eviction Moratorium. I want to thank the attendees because in many cases, entrepreneurs tend to try to go it alone, and getting detailed information can make a tremendous difference in terms of your ability to understand what the resources are out there. So I really applaud you for having done that. Thank you also to our great panelists who have really provided good detailed information. And I think, keep in mind that they are, while they're giving you good information in this case, it's still the tip of the iceberg. There are a lot more services that are available through Start Small, Think Big, who has good relationships with a variety of great attorneys like Rachel. But there's also SCORE, which can help you evaluate your business situation, help you make determinations as to, well, okay, how much will it cost me to move my business? How would I go about evaluating that? Is pivoting my business so I can use the existing space more useful than moving? Those kinds of things may be stuff that you might want to think about with SCORE. Also want to thank the interpreters. It's important to us to be able to reach as many businesses as we can in the area, and that means being able to connect up with them in languages that they're able to absorb this very complicated information in. So again, thank you for the interpreters. And I also want to thank my colleagues who made this happen. You don't always see them in the foreground, but Melina, Nate, Joe, and Elizabeth are making it possible for us to be able to hold this webinar and convey this information to you, the attendees. So again, thank you so much for being here. There is a survey. Once you get done with the webinar, you should receive a survey, and please remember to complete that so that we have a better understanding about how the webinar is working for you and get any suggestions that you have. Again, we do offer this webinar, basically these types of webinars every other week. If you haven't already, you can sign up for the City of San Jose's email notices and be able to follow up with that. I will be, that is to say, connect up with our email notification system so that you are alerted to these kinds of things in the future. I will be following up with each of these presentations so you can look at them in more detail. We have been recording these this webinar in all the languages of the interpretation, and those will also be available. I'm not going to distribute those, but you'll be able to get a hold of them. Again, we really appreciate you being here. We hope that you've gotten good value from this event, and we hope to see you either next week for a more general discussion as part of our SJ Biz Chat, or sorry, Biz Chat SJ, or in 2 weeks when we're talking about more financing issues. So again, thank you all for being here. You have a great evening. And again, we'll hope to see you next week.